Hello everyone, this is Crypto BitLaw back with another video for you today. This video is going to focus on the Hex Class Action complaint that was filed in federal court. What we're going to do is give a breakdown of this complaint, also sometimes referred to as a lawsuit that was filed, and we're going to do a deep dive into it and parse it out piece by piece. So this video may be a little more technical than some of our previous videos because we're going to go through the lawsuit and analyze each different part and give some analysis to why it was structured the way that it was structured and what different functions each part of the lawsuit serves in the grand scheme of things. As always, nothing here is intended as legal or financial advice. Also, if you like this content, please give us a like, subscribe to our channel, drop a comment in the comment section below, and also please follow us on Twitter. We are at Crypto BitLaw. So diving right in, we can see the caption right here. The plaintiff is listed as Ryan Cox. Now we don't know exactly who Ryan Cox is, but some basic searching revealed that Ryan Cox may be a financial advisor based out of Arizona. This is based off of a LinkedIn profile that we found. We can also see that the defendants are listed as CoinMarketCap, which was purchased by Binance in 2020, Binance, including various subsidiaries of Binance such as BAM Trading Services Incorporated, which is Binance.us, Changpeng Zhao, also known as CZ, the CEO of Binance, Catherine Coley, who is the former CEO of Binance.us, Yi He, the co-founder and CMO of Binance, Ted Lee, the Binance Chief Growth Officer, and John Does 1 through 10. Now, the reason that an attorney would choose to list a John Doe in a lawsuit is because if at the present time that the lawsuit was filed, you don't know the actual identity of a particular defendant, and that identity may be revealed throughout the discovery process, you can actually go back and then amend the complaint to include the revealed identity of those defendants after the fact in the amended complaint. So for example, this situation arose in some of the file sharing lawsuits that happened in the past. Imagine a situation where you're attempting to sue someone that you suspect is guilty of file sharing, illegally sharing a copyrighted music file or something like that, and you don't know who exactly they are, but you do have an IP address. You can list that defendant as a John Doe, and then through the means of the liberal discovery process that our court systems provide for, ultimately eke out the information in order to link that IP address to a particular defendant and then actually name that defendant whose name you revealed through the discovery process in the lawsuit in the amended complaint. We can also see here that the venue for this particular complaint is the United States District Court for the District of Arizona. So it is presently in fact. We can also see that the plaintiff's attorneys here are the Davalier Law Group, LLC, which based on an internet search, we pulled up their website, and it is a Louisiana-based firm who, quote, provides an extensive array of services across a number of practice areas and industries in connection with business acquisition, organization, development, expansion, litigation, and alternative dispute resolution. Their office is located at 935 Gravier Street, Suite 1702 in New Orleans, Louisiana. They also have another office located in Idaho, and another one located in Phoenix, Arizona. Right here it states that the type of action is a class action complaint, and the plaintiff demanded a jury trial. So moving along, we can see the introduction of this complaint. The first paragraph pretty much provides an explanation of cryptocurrencies as digital assets. The second paragraph states that Hex is a cryptocurrency. The third paragraph alleges that the defendants have illegally worked to artificially suppress the value of Hex and inflate the value of other crypto. This fourth paragraph states the procedural rules upon which the basis of this lawsuit is brought into federal court, which is Rule 23 of the Federal Rules of Civil Procedure that outlines the rules of bringing class action suits. Paragraph 5 explains who the defendants are and what roles they play. For example, CoinMarketCap is a crypto ranking site. Binance is an exchange. Paragraph 6 provides an overview and an explanation regarding the relationship between exchanges, coin ranking sites, and retail investors. The plaintiffs use an article written by Nick Carter, who's a partner at a venture capital firm, Castle Island Ventures, and the co-founder of coinmetrics.io, as the basis for their argument. They quote the article by stating, in pertinent part, quote, "Ranking sites are squarely at the center of the extractive game that siphons money from the retail investors and deposits it into the pockets of altcoin creators and exchange operators." Paragraph 7 provides more analysis from the Nick Carter article. This paragraph argues that, quote, "The business model of the coin ranking sites is to generate revenue by linking consumers with affiliated exchanges where they can buy and sell crypto." Paragraph 8 provides an infographic from the Nick Carter article that illustrates the relationship between exchanges, retail investors, crypto projects, and coin ranking sites. So after the introduction, we move on to the part of the lawsuit that goes over the parties, the jurisdiction, and the venue. So the reason that this is included in a lawsuit is that a proper lawsuit must pass certain procedural bars or else it will be dismissed for failure to meet those requirements. The lawsuit must properly name the parties to the suit, state why the particular court has jurisdiction over the matter, including both subject matter jurisdiction, which is jurisdiction over the subject matter of the suit, and personal jurisdiction, which is jurisdiction over the parties, and the lawsuit must be filed in the proper venue. So when you have all three of those things at the same time, and they're correct, you have a properly filed lawsuit. With regards to the parties, you have to name the proper party, because if you name a particular party and it wasn't the actual party that was involved in the particular suit, the defendant can come back and say, hey, that wasn't me. And if they can actually prove that up, the court would just kick the lawsuit right out. Same thing with jurisdiction. There's two types of jurisdiction. Personal jurisdiction, which is, jurisdiction of a court over a particular person or entity, and subject matter jurisdiction, which is the jurisdiction of the court to hear a particular subject matter. With regards to personal jurisdiction, a court needs to have jurisdiction over that particular person as it relates to the facts alleged in the suit. So, for example, if both the plaintiff and the defendant were domiciled in California for acts that happened in California, and you tried to sue them in Arizona, an Arizona court wouldn't have jurisdiction over that defendant. With regards to subject matter jurisdiction, a particular court has to have jurisdiction over that given subject matter. Certain courts can only hear certain types of cases. So, for example, there are bankruptcy courts that only hear bankruptcy cases. So if you file a personal injury action in a bankruptcy court, that court wouldn't have jurisdiction over that subject matter. And it's the same thing with venue. The venue needs to be proper too. Just like the earlier example with a California-based defendant and plaintiff with a cause of action that arose in California, if you try to sue the defendant in Arizona, that wouldn't be the proper venue. You'd have to do it in California. So that's why you need all three of those things to exist and to be proper in order to have a properly filed lawsuit. So moving along from our brief little civil procedure lesson, we could see that paragraph 9 states that the plaintiff, Ryan Cox, was at all times relevant hereto a resident of Yavapai County, Arizona. And as we alluded earlier, this is for jurisdictional purposes to establish that Ryan Cox is a resident of Arizona. Paragraph 10 states that the plaintiff acquired Hex prior to the suppression period, where the suppression period is going to be defined below. Paragraph 11 states that the plaintiff sold some Hex during the suppression period. Paragraph 12 states that the plaintiff's acquisition and sale of Hex occurred while he was physically located in Arizona. Paragraph 13 is a jurisdictional statement regarding the location and headquarters of the defendant CoinMarketCap. It states that CoinMarketCap is a Delaware LLC that's headquartered in Delaware. It further states that CoinMarketCap is widely used by Arizona investors. Paragraph 14 is an excerpt from CoinMarketCap.com's website regarding its mission statement, and this is likely included for the jurisdictional purposes to bolster the plaintiff's argument that CoinMarketCap operates in Arizona and is thus subject to that court's jurisdiction, the Arizona District Court where this lawsuit was filed. Paragraph 15 states that CoinMarketCap.com is sponsored by Blockchain.com. Paragraph 16 explains the relationship between Binance and CoinMarketCap and states that, quote, CoinMarketCap.com was acquired by Binance Capital Management Co. Limited, also known as Binance, a limited liability company, in early of 2020. Paragraph 17 establishes that CoinMarketCap is a subsidiary of Binance and provides a screenshot of a Crunchbase article detailing Binance's acquisition of CoinMarketCap. Paragraph 18 presents a quote from a CoinDesk article titled, "They Have Users. Binance CEO explains why he bought CoinMarketCap." The paragraph states, quote, "In lauding the acquisition, Zhao stated, CoinMarketCap has more users than any other product in the crypto space. Even though their money generation mechanism is not as strong as Binance, they do have the users. It's a very valuable platform." Paragraph 19 provides a quote from crypto derivative trading platform CEO Andy Chung, who stated that the acquisition was, quote, "not very good for the industry, given the conflict of interest between the parties' missions," and that Chung pointed to Binance's exchange token, BNB, aka Binance Coin, as an example. Paragraph 20 provides a quote from Binance explaining its purpose in purchasing CoinMarketCap, stating, quote, "Through the acquisition, CoinMarketCap plans to tap into its parent company's extensive resources to acquire more in-depth data into projects, reduce information asymmetry in the crypto industry, and bring higher quality data to its hundreds of millions of users." Paragraph 21 provides quotes from CoinDesk that explain how CoinMarketCap is a dominant data source and go-to platform for asset pricing in the cryptocurrency space, as well as the first landing page for retail investors. Paragraph 22 provides a quote from a Forbes article explaining that CoinMarketCap can leverage its size and reputation to quote-unquote hide a cryptocurrency at will. Paragraph 23 provides more quotes from the Forbes article, stating that CoinMarketCap.com's dominance provided the, quote, "option for collusion, corruption, and coercion." The Forbes author further noted that CoinMarketCap.com seemed to reduce some market caps arbitrarily, leaving, quote, "investors and traders confused," and, quote, "damaging the reputation of cryptocurrencies so impacted." The author concluded that CoinMarketCap.com's flawed rankings were dangerous and posed a risk to retail investors. Paragraph 24 gives some quotes from the Nick Carter article explaining how CoinMarketCap has the ability to artificially inflate the value of a cryptocurrency. It also cites a relationship between CoinMarketCap and the BitConnect Ponzi scheme fraud. Paragraph 25 presents quotes from the CoinMarketCap website regarding Binance's mission statement. Paragraph 26 provides an explanation of Binance's purpose as a cryptocurrency exchange. Paragraph 27 presents a statement alleging that Binance's CEO, defendant Changpeng Zhao, founded Binance in China, but shortly thereafter moved Binance's headquarters to Japan in advance of the Chinese government's ban on cryptocurrency trading. In paragraph 28, it states that in March 2018, as a result of increasing regulatory scrutiny in Japan, Binance moved its nominal headquarters to Malta. However, Zhao has stated that Binance.com has always operated in a decentralized manner as we reach out to users across the more than 180 nations worldwide, as well as pushing the envelope and experimenting on how to become a true DAO, decentralized autonomous organization. Paragraph 29 states that Malta, for its part, has announced that Binance is not under its jurisdiction. Quote, "Since then, Binance has not stated just where exactly it is now headquartered." Now, paragraph 30 is great. This one's really juicy. This paragraph tries to illustrate how Binance seeks to avoid jurisdiction through decentralization. The paragraph states, quote, "CoinDesk has reported on Zhao's 2020 response to one questioner who asked where Binance was headquartered. Then it hit. Shin asked the one question Zhao really didn't want to have to answer, but many want to know. Where is Binance headquartered? Little wonder that when asked, Zhao reddened. He stammered. He looked off camera, possibly to an aide. Well, I think that what this is the beauty of the blockchain, right? So you don't have to, where's the Bitcoin office? Because Bitcoin doesn't have an office, he said. The line trailed off. Then inspiration hit. What kind of horse is a car? Zhao asked. Binance has loads of offices, he continued, with staff in 50 countries. It was a new type of organization that doesn't need registered bank accounts and postal addresses. So this right here strikes at the heart of one of the main issues with Binance. By seeking to avoid a centralized office, residency, or headquarters, Binance is attempting to avoid falling under the jurisdiction of a particular nation or state. Essentially, Binance is attempting to avoid regulatory scrutiny, compliance, and jurisdiction through decentralization. Paragraph 31 provides a quote from Nick Carter that calls Binance a, quote, casino that hops around from jurisdiction to jurisdiction to avoid the watchful eyes of regulators, and claiming that it has a, quote, devil-may-care attitude towards compliance, KYC, and AML, wash trading, and reporting. For those of you that are unaware, AML is anti-money laundering. It's an umbrella term used for the range of regulatory processes firms must have in place, whereas KYC, know your customer, is a component part of AML that consists of firms verifying their customer's identity. These processes are part and parcel for regulatory agencies keeping tabs on their customers, ensuring that taxes are paid and funds are not used illegally. Paragraph 32 is a statement alleging that Zhao, CZ, the Binance CEO, resides in Taiwan. Paragraph 33 is an allegation that outlines defendant Yi Hei's role in Binance as a marketing officer and alleges that she resides in Malta. In paragraph 34, it's alleged that Ted Lin is Binance's chief growth officer, and it states that he is not an Arizona resident. Paragraph 35 states that Binance has no clearly defined physical headquarters. However, it engages in business in the United States. This paragraph goes to jurisdiction. In paragraph 36, it notes that Binance was banned in the U.S. in 2019 because of regulatory issues. In paragraph 37, it states that as a result of the ban, Binance launched Binance US in an effort to comply with U.S. regulation. Paragraph 38 states that Catherine Coley was the CEO of Binance US from its inception until May 2021. It further states that she does not reside in Arizona. Turning to paragraph 39, it states that Catherine Coley was replaced as CEO by Brian Brooks, a former banking regulator. It also notes that the plaintiff will seek leave to add him as a defendant of the suit if discovery reveals that he is liable for the acts or omissions that form the basis of the lawsuit. Now, this is interesting because Brian Brooks recently appeared at the congressional hearing where a bunch of crypto CEOs testified before Congress regarding crypto regulation. And of all the CEOs that testified, I think that Mr. Brooks was one of the most eloquent and well-spoken and knowledgeable of all of the witnesses, and he really put on a good show and represented crypto in a pretty good light. So it's interesting to see that he left Binance and went to a different company soon thereafter. I don't know if he was, got wind of something suspicious or fishy, who's to say, but it's interesting how the tides have turned on that. Paragraph 40 states that it's presently unknown who the CEO of Binance US is, and they will be added to the suit if it is revealed that the current CEO is culpable. Paragraph 41 alleges that Binance US is supposedly operated by BAM, but uses Binance's wallet, matching engine, and other technologies. This is likely inserted to insinuate that Binance US is operating under the corporate veil of BAM Trading Services Incorporated. However, it's still using all of the technology and the crypto wallets as Binance, and it may be possibly masquerading under the veil of Binance US. Paragraph 42 states that upon information and belief, Binance and/or Zhao own a significant portion of Binance US. 43 states that Binance US offers a very similar interface and feature set to its worldwide counterpart. 44 states Binance US has been banned in 7 US states. 45 states that Arizona is not one of the states in which Binance US has been banned. 46 states Binance and/or Binance US thus continues to operate in Arizona. 47 states Binance US sought and obtained licensure as a money transmitter. Paragraph 48 is interesting. It states that in May 2021, Bloomberg News reported that Binance was under investigation by the United States Department of Justice and Internal Revenue Service for money laundering and tax evasion. 49 states that collectively, CoinMarketCap.com, Binance, and Binance US are referred to as the, quote, corporate defendants. Paragraph 50 lists the individuals named, particularly CZ, Catherine Coley, Yi Hei, and Ted Lin, as the individual defendants. Paragraph 51 states the individual defendants are all persons who possess significant knowledge about cryptocurrencies and are well equipped to know Hex's true market cap. Now, paragraph 52 is interesting. It states that next to each cryptocurrency listed on CoinMarketCap.com is a buy button, and then it seeks to provide some screenshots of the buy button, as we can see here and here, of the listings and the buy button on CoinMarketCap.com. And this is important because the plaintiff is trying to establish that the defendant has a significant financial interest in the operations of CoinMarketCap. Paragraph 53 states that users who click on the, quote, buy button are directed to either blockchain.com or Binance's website. 54 continues and states that, however, despite appearances to the contrary, Hex cannot be purchased via either blockchain.com or Binance. Paragraph 55 states the link on CoinMarketCap.com website that takes users to the Binance.com website does not inform users that they are being directed to a Binance subsidiary, but instead invites users to purchase cryptocurrency through Binance. Similarly, the landing page at which users arrive at after clicking the link states that the site belongs to Binance in the upper left-hand corner and directs users to Binance's website. 56 continues and states that, in contrast, the words Binance.us are prominently displayed in the upper left-hand corner of Binance US's website. Paragraph 57 states that the, quote, terms section of the website to which CoinMarketCap.com users are directed makes clear that, quote, Binance refers to an ecosystem comprising Binance websites. And then it lists a bunch of the subsidiaries and the ecosystems that are under Binance's control. Paragraph 58 states that the, quote, about Binance paragraph of the terms portion of the website states that Binance mainly serves as a global online trading platform for digital asset trading. 59 continues and states that the terms section further notes that Binance operators are bound by the terms expressed there. Paragraphs 60 and 61 continue to link Binance and its subsidiaries to the terms that were listed above. Paragraph 62 continues the connection, but it states in pertinent part that no mention in those terms is Binance US being listed as a distinct separate part of that ecosystem, thus distinguishing itself, Binance US that is, from the larger Binance ecosystem as a whole. Paragraph 63 provides some information from Binance's website where it states that its vision is to, quote, increase the freedom of money globally and spread this freedom to significantly improve lives around the world. Paragraph 64 states that the website CoinMarketCap.com users are directed to lists Binance as part of its ecosystem. 65 continues by stating that the website also lists Binance Info, in other words, CoinMarketCap.com, as part of its ecosystem, and claims that it serves as an open and objective information platform. This is despite the fact that prior to acquiring CoinMarketCap.com, Zhao had criticized the quality of its data, and that a 2019 report to the SEC found that CoinMarketCap's data was based in large part on artificial trade volume. Paragraph 66 establishes another link between Binance and CoinMarketCap and states that clicking on the link for Binance Info takes users to CoinMarketCap.com's website, and then it provides a screenshot down here of the connection. Paragraph 67 pretty much wraps up a lot of the previous paragraphs into a nice little bow and provides the conclusion that all of those allegations were leading up to. It states, thus, it is simply not clear where Binance ends and Binance US begins, or even whether there is any meaningful distinction between the two at all. Paragraph 68 here really strikes at the heart of the matter of this entire suit. It states that although Binance bills CoinMarketCap.com as an open source platform to which any user can contribute, users cannot change Hex's ranking. Rather, the power to change that ranking is under the control of the defendants. Paragraph 69 establishes an allegation that Binance and Binance US make money by charging a transaction fee to those who execute transactions of the cryptocurrencies traded on those exchanges. Paragraph 70 continues and states that Hex is not traded on Binance or Binance US. Paragraph 71 touches on those John Does that were mentioned earlier as part of the parties, and it alleges that they are either natural or corporate persons which may be liable for the acts or the omissions complained herein. And it states that the plaintiff will continue to seek leave to add their true names after the discovery reveals their identities. Paragraph 72 is a jurisdictional statement that provides the basis of law that gives this particular court jurisdiction to hear this case. Paragraph 73 is pretty much the same thing. It's another jurisdictional statement that provides laws that form the basis of the court's jurisdiction over this case. Paragraph 74 provides the applicable law for why venue is proper in this case and why this is the proper venue for this court to hear this case. So turning now, we come to the next section of this complaint, where it states CoinMarketCap.com's representations to the public. And then paragraph 75 and 76 seek to incorporate references to CoinMarketCap.com's websites and the representations made therein. So some points of note about CoinMarketCap's representations to the public. CoinMarketCap strictly follows and enforces its independent listing criteria, guidelines, and circulating supply calculation methods and liquidity score for how it ranks crypto assets. Crypto assets that are listed will be fairly and independently evaluated on their merits. Their official ranking criteria is designed to eliminate any possibility of preferential treatment. They'll continue to present the most accurate data on cryptocurrencies. It continues that CoinMarketCap's mission is to provide all users with the most accurate and relevant information to select exchanges and tokens to invest in. Paragraph 77 really hammers home the crux of the plaintiff's arguments here in this suit. It states that despite CoinMarketCap.com's promises of objectivity and fairness, the site has a history of manipulating its rankings to benefit Binance. Paragraph 78 provides a pretty good example from a May 15, 2020 Cointelegraph article that reported that CoinMarketCap changed its methodology to rank exchanges on their web traffic by default, a metric that puts CoinMarketCap's new owners, Binance, in the top spot. And the change stands in stark contrast to the words of CoinMarketCap's chief strategy officer, who once stated that web traffic was not a good indicator. Paragraph 79 is another explanation of the changes that were implemented in order to favor Binance. Paragraph 80 states that CoinMarketCap.com's glossary defines rank as the relative position of a cryptocurrency by market capitalization. And it states that this is the industry norm and that most individuals track cryptocurrency ranks according to market cap. Paragraph 81 continues and states that market capitalization, or market cap, is calculated by multiplying the price of a cryptocurrency with its circulating supply at any given time, according to the CoinMarketCap.com website. Paragraph 82 states that as of September 13, 2021, between noon and 1 p.m., CoinMarketCap.com stated that Hex's price was 34 cents. Paragraph 83 states that as of that date and time, CoinMarketCap.com stated, quote, "The CoinMarketCap team has verified Hex's circulating supply to be 173,411,074,413. Paragraph 84 states that CoinMarketCap represented as of that date and time, the CoinMarketCap team has verified the Hex market cap to be $62.2 billion. This sum is the product of multiplying the price reported by CoinMarketCap with the circulating supply verified by CoinMarketCap." This paragraph is accompanied by a screenshot where you could see the quote stated above that the CMC team has verified the project's market cap to be $62.2 billion. Paragraph 85 is a statement that CoinMarketCap's homepage bills itself as displaying a list of, quote, "today's cryptocurrency prices by market cap." Paragraph 86 is one of the big conclusion paragraphs that states that Hex's verified market cap should see it ranked 6th, near the top of the first page as of September 13, 2021. This ranking would place it between Binance Coin and XRP. Paragraph 87 provides the counterpoint that says, instead, Hex was ranked 201 on the third page of results. Now we continue on to the next section of the complaint, general allegations. Paragraph 88 and paragraph 89 are pretty much wrap-ups of what just happened. And then paragraph 90 states that Hex was the best performing cryptocurrency of 2020, but CoinMarketCap locked Hex's ranking at 201 sometime that year, and it refused to adjust it based on Hex's performance as related to other cryptocurrencies ever since. And it refers to that period as the suppression period. Paragraph 91 continues and alleges that CoinMarketCap.com provides its historical rankings on its website. 92 states that these historical rankings reveal that Hex was ranked 20th as recently as September 20, 2020, in line with CoinMarketCap.com's estimation of Hex's market cap. Paragraph 93 continues that, however, by September 27, 2020, the suppression period had begun. 94 states that Hex's ranking remains locked. Paragraph 95 states that CoinMarketCap doesn't provide enough data to decipher when exactly the suppression period began, but the plaintiff expects that that information will be revealed in discovery. Right here in paragraph 96, we get to another zinger. It states that CoinMarketCap.com's locking of Hex, the Hex ranking, has caused Hex to trade at lower prices than it would have had the ranking not been locked. Paragraph 97 alleges that the higher a cryptocurrency is ranked, the higher up it appears on the homepage of CoinMarketCap.com's website for interested users to purchase. 98 continues that users must scroll through additional pages to view lower-ranked cryptocurrencies. Paragraphs 99 through 105 provide a general overview of Binance Coin, its relation to CZ and Binance, how they have a financial interest in ensuring a strong possible demand for Binance Coin, and how it is ranked on CoinMarketCap.com. Paragraph 106 introduces the Nomics coin ranking site, and it states that Nomics ranks as Hex's true market cap at $85.3 billion as of July 21st, 2021. 107 continues and states that at that market cap, Hex should have been ranked third in size as of July 21st, 2021. As of that same date, CoinMarketCap.com listed Hex's market cap as just over $25.6 billion. 109 continues that even at that market cap, Hex should have been ranked sixth. 110 states that instead, Hex was ranked at 201 on CoinMarketCap. Therefore, we can see in paragraph 111, as of July 21st, 2021, Hex was ranked on the third page of CoinMarketCap.com's results. Paragraph 112 states that upon information and belief, some other websites that allow users to buy cryptocurrencies also present them in the order they are found in CoinMarketCap.com's market rankings. So it's pretty much saying that other websites where users can buy and exchange crypto use CoinMarketCap's data to facilitate their rankings. Paragraph 113 gives an example of other smaller ranking websites such as Nomics and CoinRanking.com that had Hex ranked between 4th and 10th in size as of June 18th, 2020. Paragraph 114 pretty much lays out the basis of the damage that was caused to the plaintiff by the suppression. It states that CoinMarketCap.com's failure to properly rank Hex has artificially suppressed Hex's value to the detriment of plaintiff and those similarly situated. Paragraph 115 expounds upon the previous point and states that but for CoinMarketCap.com's failure to properly rank Hex, at least some individuals who purchased higher ranked cryptocurrencies would have purchased Hex instead, and that suppressed the price of Hex and inflated the price of one or more other cryptos, including those issued by Binance. Paragraph 116 continues and states that CoinMarketCap's failure to properly rank Hex had the effect of directing buyers away from Hex and towards cryptocurrencies that could be purchased through blockchain.com or Binance. Paragraph 117 states that this gave a financial advantage to CoinMarketCap, Binance, Binance US, blockchain.com, and individuals associated with those companies. 118 states that CoinMarketCap's failure to rank Hex properly artificially inflated the value of some or all of the currencies ranked above Hex, including those issued by Binance. 119 states that Hex is heavily traded, and for the 24 hours ending July 21st, 2021 at 7:35 p.m., CoinMarketCap.com reported that Hex trading volume was at $79 million. Trading volumes during each of the prior 7 days was higher. Between May 22nd of 2021 and July 21st of 2021, the lowest daily trading volume was 22.9 million. Paragraph 120 and 121 state that Hex and other cryptos received widespread coverage in the financial press and by cryptocurrency analysts, and according to Coindex.com, as of July 22nd, 2021, there were 13 exchanges on which Hex could. Paragraph 122 establishes a causal relationship between the unexpected material disclosures and the price of Hex. And then 123 gives an example and states that the inventor of Hex created another cryptocurrency called Pulse Chain. It was recently made public that holders of Hex would have the opportunity to acquire this new cryptocurrency at an earlier phase than others, causing or contributing to an increase of the price of Hex. 124 continues and states that such a cause and effects relationship exists for many other cryptocurrencies listed or offered for sale by the defendants as well. 125 concludes that the market for Hex, and some or all of the cryptocurrencies ranked above Hex by CoinMarketCap is efficient. This brings us to the next section of the lawsuit, the ill will of the defendants towards Hex and its creators. And 126 is a boilerplate where it just pretty much establishes that the plaintiff is incorporating all of the references of everything listed above. This section continues with 127 that states that Bitcoin is the world's largest cryptocurrency by market cap. And in 128, it states that upon information and belief, Bitcoin is also the most commonly traded cryptocurrency on Binance and Binance US's exchange. 129 states that CZ stated in a February 2021 interview that he keeps nearly 100% of his 1.9 billion net worth in cryptos. And upon information and belief, he also stated that Bitcoin is one of his favorite cryptocurrencies to hold. 130 continues and states that all individual defendants have large holdings of Bitcoin, Binance Coin, Binance USD, and other cryptos. 131 continues and states that Hex was intended, in part at least, to serve as an alternative to Bitcoin's model, and that if Hex succeeds, the price of Bitcoin and other similar cryptos would be lower than it would otherwise be, creating a financial detriment to the individual defendants. 132 alleges that all of the individual defendants have substantial crypto holdings, and 133 states that upon information and belief, none of the defendants own any Hex. Paragraph 134 pretty much gives an overview of counterparty risks and gives an example about how if holders of Bitcoin were to earn interest, they'd have to give their private key to third parties, and how that increases the risk of theft. And as a counterpoint, Hex is designed to allow users to earn interest without that sort of counterparty risk. Paragraph 135 states the obvious, that none of the corporate defendants can make money off of Hex the way that they do off of other cryptos, because Hex is not traded on Binance or Binance US exchanges. 136 continues and states that Hex is designed to generate interest when staked, which discourages active trading. If the Hex model succeeds, it will further undermine the businesses of exchanges like Binance and Binance US and coin ranking sites like CoinMarketCap, insofar as exchanges make money only when investors trade, and coin ranking sites make money by sending such investors to exchanges to trade. So that's a lot of the same points that Richard Hart, the founder of Hex, has made and explained in his overviews of Hex and how Hex was designed. Paragraph 137 states how right before the suppression period, Binance launched the Binance Smart Chain, and it states that the Binance Smart Chain is a direct competitor to Hex. 138 states that Binance Coin was created as a utility token for discounted trading fees on Binance's exchanges, and such fees could also be paid in Binance Coin. 139 alleges that the Binance Smart Chain allows other cryptos built on the Binance Smart Chain to be staked. 140 states that Hex is not built on the Binance Smart Chain. And 141 continues that the defendants financially benefit from the adoption of both Binance Coin and the Binance Smart Chain by investors. The next paragraph continues that the defendants' actions have limited the adoption of Hex and thus made it more difficult for Hex's model to succeed. 143 names Richard Hart as Hex's creator and states that he's a vocal critic of Binance and CoinMarketCap.com. And 144 concludes that persons with a close connection to CoinMarketCap.com have also expressed a personal dislike of Hex's creator, Richard Hart. So this brings us to the next section of the complaint, the class action allegations. And in paragraphs 145 through paragraph 156, the plaintiff provides the legal basis under which all of these class action plaintiffs should be brought in this class action suit. In particular, it states that this suit is brought pursuant to the Federal Rules of Civil Procedure on behalf of all persons who sold Hex during the suppression period, which they had acquired prior to the suppression period, and names those individuals as the class. It further states that the members of the class are so numerous that joinder of all members is impracticable. That's why they want this to be brought as a class action suit. It also states, as of July 23, 2021, Hex was held by over 300,000 unique wallets. It also states in pertinent part that the amount in controversy far exceeds $5 million. Now, this was included because there is a procedural rule in federal court. In order to get something known as diversity jurisdiction, the amount in controversy has to be greater than $75,000. This section also continues and states that there are common questions of law and fact between the class members, including whether the defendants violated the Commodity Exchange Act, whether defendants omitted or misrepresented material facts, whether the price of hex has been artificially suppressed, and others. So this brings us to the next section of the lawsuit. This is where the plaintiff outlines the different causes of action for bringing the suit. These are the reasons why the plaintiff is suing the defendants. And the first cause of action is a private cause of action under the Commodity Exchange Act for manipulation of commodity prices and provision of false, misleading, or knowingly inaccurate reports tending to affect the price of commodities. So here, the plaintiff is alleging that the defendants, all defendants, violated this particular law, 7 U.S. Code Section 25, the private rights of action. And it provides a right of action against any person who violates U.S. Code Title 7, Chapter 1. And in particular, the plaintiff asserts that according to the law, it is unlawful for any person to manipulate or attempt to manipulate the price of any commodity in interstate commerce, or knowingly to deliver or cause to be delivered for transmission via telegraph, telephone, wireless, or any means of communication, false or misleading or knowingly inaccurate reports concerning to crop or market information or conditions that affect or tend to affect the price of any commodity in interstate commerce. So here in this section of the lawsuit, pretty much paragraphs 161 through 193, it pretty much applies that law, the black letter of that law that we just read through, to the facts of this case that were previously alleged, and links the actions or omissions of the defendants to that law, and pretty much outlines how the defendants broke that law and manipulated the price of these cryptocurrencies. And we can see here, we could do a deeper dive about exactly how they did it, you know, with the untrue statements, the artificial suppression, so on and so forth. And these paragraphs, 161 through 193, in sum, pretty much link all the defendants' acts or omissions to that law and explain how they violated that law. So just to give a brief overview, this section states in relevant part that the defendants had the motive to perform the acts and omissions complained of in order to limit the threat Hex posed to their business models, and that this was done because of the personal animus against Hex's creator. It also continues that the defendants either willfully participated in the manipulation or failed to review or check information that they had a duty to monitor, or ignored obvious signs of market manipulation. And for these reasons, and other reasons set forth herein, the defendants have violated the Commodity Exchange Act. And that because of the defendants' actions, the plaintiff and the class have been directly damaged. The plaintiff also gives an example of the damage that was done and states that upon the sale of their hex, the members of the class would have either lost money or failed to make profit they would have otherwise have made upon that sale of their hex, but for the defendant's manipulation. And this brings us to the second cause of action, the next section of the lawsuit, and it is strict liability for the violations of the Commodity Exchange Act, and this is alleged against Binance and Binance US. Now this section is interesting because it asserts that the laws that the defendants, Binance and Binance US, violated incorporate this legal doctrine known as respondeat superior, and that liability under that doctrine applies to violations of the Commodity Exchange Act. And just to give a brief overview of respondeat superior, it is a Latin term that literally means let the master answer. And it is most commonly used in tort law, but it holds that an employer will be liable. An employer or principal, they're legally responsible for the wrongful acts of an employee or agent if such acts occur within the scope of employment or agency. So here they provide a case, just to give a little bit of jurisprudence over the basis of why they are alleging this. And then they continue by asserting that private causes of action for respondeat superior liability for violations of the Commodity Exchange Act comport with Congress's view that private lawsuits are critical to protecting the public. So then they also provide some more case law to support their position regarding this interpretation. So essentially what the plaintiffs are doing here, they're strategically trying to bring in and hold Binance and Binance US liable for the acts or omissions of the employees, in particularly the named defendants, the individuals like CZ and Hay and so on and so forth. So strategically, this is a pretty good decision, because by trying to hook in the employers, Binance and Binance US, they're trying to rope them in the event that the employers put up a defense and say, hey, we're not responsible for this. This was actually the employees. This was actually CZ and Hay and Cooley. And the reason you want to have access and you want to bring in and rope in the employers is that you always try to follow the money. You want to go where the deepest pockets are. It'd be one thing to get a judgment against someone that doesn't really have the ability to pay for it, like an individual. It's another thing to get it against a large corporate entity that has really deep pockets. So in the event that you do get a large judgment, you can actually see that it's paid out through the pockets of the corporate defendant. One of the other reasons that the plaintiffs are attempting to allege liability under respondeat superior is they're trying to incorporate the section of law, the branch of law known as tort law, which has a different legal framework than that of contract law. So if you can attack this on two different fronts, you'll have one front where you're attacking under the rules and regulations that apply to contracts, and another one where you're attacking it under the framework of all of the different tort laws. So pretty much you're getting two bites at the apple. If one fails, at least you have another framework or schema of law to work under. So another thing that the plaintiffs are trying to do here is do what's known as piercing the corporate veil. It's a term of art in law that refers to situations where courts set aside limited liability that's commonly afforded to certain business entities like LLCs or corporations, and the court will hold the shareholders or the directors personally liable for the corporation's actions or debts. And so by doing that, they're trying to broaden their horizon of potential pools that they can take from and potential defendants that would be liable for these acts. Normally, when you set up a corporation or an LLC, one of the main reasons to do that is to have a liability shield between you as a shareholder or a director of that corporate entity and the actual actions that that entity engages in. So it kind of acts like a shield or a veil, the entity does, and it protects the shareholders or the agents or CEOs, what have you. It serves as a line of protection between the entity, the corporation, and what it does, and the shareholders. So in sum, in these paragraphs for this section, 194 through 216, it pretty much tries to rake in Binance, Binance US, pierce the corporate veil, draw a connection between the agents of those corporate entities and the actions of this company, as well as the actions of the individual, link them all together, pierce the corporate veil, bring them under the umbrella of tort liability, and it states in sum, for these reasons set forth above in this section, Binance and Binance US are jointly and severally liable for the torts of CoinMarketCap.com. And then it also states alternatively, and you could do something in law known as argue in the alternative, where you pretty much give out two arguments. You say, hey, this is my first argument, and if you don't like this, this is my fallback argument. Alternatively, if you don't buy what I'm trying to sell you in the first argument, here's my fallback. And that's what they did here. They argue in the alternative. They say, alternatively, for these reasons and the other reasons set forth herein, the corporate veil should be pierced between Binance, Binance US, and CoinMarketCap.com. So ultimately, what they're asking for here is to hold Binance and Binance US, the corporate defendants, liable, And if the court's not willing to do that, the plaintiffs are trying to say, hey, if you're not willing to hold Binance and Binance US liable, at least allow us to pierce the corporate veil and go after the individual defendants. CZ, Hay, Cooley, so on and so forth. So now we move on to the third cause of action, which is a violation of Arizona's Consumer Fraud Act, and this is alleged against the corporate defendants. And in this section, they begin with a statement of the Consumer Fraud Act, which makes unlawful the, quote, use or employment by any person of any deception, deceptive or unfair act or practice, fraud, false pretense, false promise, misrepresentation, or concealment, suppression, or omission of any material fact with the intent that others rely on such concealment, suppression, or omission in connection with the sale or advertisement of any merchandise, whether or not any person has in fact been misled, deceived, or damaged thereby. And then it provides a cite to the law where this is cited from. And then it continues and alleges that Arizona law provides that merchandise includes securities as well as other intangibles, and then states that cryptocurrency, such as Hex, are intangibles. This is pretty interesting. Paragraphs 217 through 235, which form the basis of this section in this cause of action, pretty much apply a lot of the facts that we learned earlier in the outline of this case about the suppression and the manipulation and all of that to this particular law. But then the plaintiffs, they take 4 different bites of the apple here by trying to apply the law to these facts. They do it 4 times, and they argue in the alternative 4 different times. Let's go over them. They state here, this is pretty much a summation of their arguments. First, on paragraph 232, plaintiff and the class have suffered damages due to defendants' fraud on the market in that they have received artificially suppressed prices in exchange for their units of Hex. And then alternatively, plaintiff and the class have suffered damages due to defendants' failure to disclose the true ranking of Hex and the cryptocurrencies ranked above it on CoinMarketCap. And then another one, alternatively, plaintiff and the class have suffered damages in that they would not have sold Hex at the prices they did, if at all, if they had been aware that the market price had been artificially and falsely suppressed by defendants' misleading statements. And then finally, alternatively, plaintiff class relied on CoinMarketCap.com to apprise them of Hex's true ranking and would not have sold Hex at the prices they did, if at all, had CoinMarketCap.com appraised them of Hex's true ranking. Okay, so that's a lot to take in, and certainly I think all 4 of those summation arguments, they do have merit, but I'm of the belief that if you can't really get it done the first time, then your second bite at the apple probably isn't really going to work out. But to do it 4 times, that's just kind of stretching it for me. I have in the past argued in my pleadings to the court in the alternative, hey, court, this is my best shot. And then in the alternative, if you don't like my best shot, this is what I've got as a backup. Maybe you can kind of see that. And sometimes that works out. I've had courts take, okay, I don't agree with you on your first one, but, you might have gotten it on the second one. 4 different alternatives? I don't know. You're kind of stretching it there. I mean, to me, that's just a personal stylistic choice. I could see why they did it. Normally when it comes to these sorts of things, a lot of times in trial and litigation, I've had mentors tell me either you don't ask and you don't get, or if you don't use it, you lose it. So I could see why they just kind of threw everything at the wall and they're trying to see what sticks. I can see why they did that strategically. But for me, it would seem to pass more muster, and it seems like you would have a better presentation if you just stuck to your best, most concise, most relevant arguments. But that's just me. So with that said, we'll turn to the 4th cause of action here in this lawsuit, and it is control person liability for violations of the Arizona Consumer Fraud Act. This is alleged against all defendants other than CoinMarketCap.com. So here in this section, we begin with the allegations and a statement of law, and the plaintiffs provide that both federal and Arizona securities law make defendant CoinMarketCap.com's controlling persons jointly and severally liable for the violations of Arizona Consumer Fraud Act complained herein. So here the plaintiffs are trying to assert that each of the defendants, other than CoinMarketCap, are liable for the violations of the Arizona Consumer Fraud Act. So this section continues and provides a review of how Binance is structured, with CZ being the CEO, and how Binance directly owns CoinMarketCap, and then provides all of the relations between these entities. It pretty much sets the foundation of how all of these defendants are connected and why they should be held liable for the violations of this particular law. So much like the previous cause of actions before, the paragraphs under this section for this cause of action, paragraphs 236 through 256, pretty much reiterate a lot of the facts that were established earlier on in the lawsuit, and then pretty much assert that because of the defendant's market manipulation, all of these defendants are jointly and severally liable with CoinMarketCap.com for the acts and omissions complained in this suit. And then it states, in relevant part right here in paragraph 256, that the structure of CoinMarketCap is itself opaque, and it's difficult for the plaintiff to ascertain which of its corporate officers, directors, and shareholders are control persons for the company. And when their identities are discovered, this complaint will be amended as appropriate. So, I mean, pretty much what they're saying is that we might not have all of the information at this time in order to allege everything as is required under law in order to comply with the black letter of the law. But when we get more information in discovery, we reserve the right to amend this lawsuit in order to comply with the law based on the new facts that are revealed. So this brings us to the fifth cause of action, which is antitrust, and this is alleged against the corporate defendants. And for those of you that are not familiar with what antitrust is, it is a body of law and regulations that encourage competition by limiting the market power of any particular firm in the market. And it often involves ensuring that mergers and acquisitions and just the general operation of a market participant does not overly concentrate market power or form monopolies. And this body of law is aimed at breaking up firms that have ultimately become monopolies. This might bring up reminiscences on Microsoft back in the day, how they were alleged to have become a monopoly in the computer operating system software market. And there are also some bells ringing nowadays about Facebook and other large tech conglomerates and whether or not they have a monopoly over those particular tech spaces. So this section for this particular cause of action is pretty straightforward. It begins with a statement of law that provides that federal law and Arizona law provide private causes of actions for antitrust violations. And it continues that the plaintiff and the class have suffered actual injury fairly traceable to the alleged conduct of the defendants. And it continues that the corporate defendant's conduct has also harmed competition for the reasons set forth in the section entitled Ill Will of Defendants Towards Hex and its Creators and elsewhere above. And it also states that the injuries sustained by the plaintiffs are inextricably intertwined with the corporate defendants' efforts to limit public adoption of Hex's alternative model and bolster the public adoption of Binance and Binance US's competing products by manipulating the ranking of Hex and therefore its price and public adoption. So pretty much they're alleging corporate market manipulation and just general antitrust behavior that's trying to limit the market power of other competing market participants. So they continue here and state that should discovery reveal that one or more of the individual defendants are liable for antitrust violations complained of above, the plaintiff may seek leave to amend this complaint to allege this cause of action against them. So they are reserving the right to amend the complaint should discovery reveal that any of the individual defendants are liable for the antitrust violations, and then lump those individuals into this particular cause of action. And then finally, we start to wrap it up and get to the end of the lawsuit here with the prayer for relief, and this is what the plaintiffs include and what they're pretty much asking the court to do for them. And they're requesting that the court assert jurisdiction over this action, that the court determines that the action be maintained as a class. So they're asking that the court certify this action and the plaintiffs named herein as a class so that they give them class action status. They want an order declaring that the defendant's action violate federal and state law. They want an award for the plaintiffs and the class for damages in the amount to be determined at trial, including punitive damages. Now, what are punitive damages? Punitive damages are typically damages, an award exceeding just base level simple compensation, and they're awarded in order to punish a defendant and serve as an example to others that may engage in similar conduct as this particular defendant. And so they're asking the court for punitive damages, and then they also want treble damages. So here we can see they want treble damages under antitrust or other applicable law. Now, certain areas of law provide for what's known as treble damages. And treble damages is usually a term that indicates that a statute exists to award a prevailing plaintiff up to 3 times the actual or compensatory damages. So, for example, let's say that a court determines that a plaintiff is to be awarded $1,000 for the defendant's wrongdoings. Under the treble damages doctrine, the court could award that plaintiff up to 3 times that original damage award. So instead of getting $1,000, you'd get 3. So the plaintiff also wants the court to enjoin the defendant's unlawful acts as set forth in the complaint and provide any other equitable relief against the defendants to which the plaintiff and the class are entitled. So they're pretty much asking the court to stop the defendants from doing what they're doing with the manipulation and prohibit them from continuing to act in such a manner. They also want the court to award the plaintiff and the class pre- and post-judgment interest, so they're asking for any interest to be assessed for any judgment that would be issued as a result of this suit. The plaintiffs also want the court to award the plaintiffs and the class attorney's fees and the cost of this suit, so that's pretty self-explanatory. They want appropriate compensation for the class representative, because you know that the lawyers that maintain the class and manage the lawsuit on behalf of the class are entitled to compensation. And they also want the court to award any and all other relief as the court may deem just and proper under the circumstances. That's pretty much the general catch-all boilerplate template language for if we missed anything, here's the catch-all, we want it. And then finally, here is the demand for a jury trial. As we can see here, under the Federal Rules of Civil Procedure, the plaintiffs are asking for a trial by jury. So normally you could have a bench trial, that's where a judge hears the case at trial, or you could have a trial by jury, and that's where a jury hears the case. And so naturally, the plaintiffs want a jury trial in this. So here we have a copy of the docket in this particular case, so we could try to see what has happened and where we currently stand in the posture of this case, what's presently going on. So we can see here it started on September 13th of 2021 when the complaint was filed, and then we progressed all the way to September 16th. There was an order that the plaintiff serve a copy of an order that was issued by the court regarding a defect on service to the defendants and file a notice of that service. So as we could see here playing out, there's been issues trying to properly serve all of these defendants that were named in this suit, which isn't really surprising considering that Binance kind of operates as this amorphous pseudo-corporate entity without really having any bona fide home, so to speak. Also on September 16th, there was an order directing the clerk of court to terminate any or all defendants in this matter without further notice that have not been served within the time required by the Federal Rules of Civil Procedure on December 13th, 2021. So they pretty much set a time limit date, like, hey, if you don't serve these people properly and then file a record of that in the court by December 13th, 2021, we're going to terminate those defendants that have not been properly served. So they set a timeline pursuant to the rules of the Federal Rules of Civil Procedure. So we continue on, and then on November 3rd, there was a pro hoc vice motion that was granted for this particular attorney, or these two attorneys, Hill and Rosser, on behalf of the defendant BAM Trading Services Incorporated. Now, for those of you that don't know, pro hoc vice, that is a legal term that pretty much it describes a situation where a lawyer who is not licensed to practice in a particular jurisdiction can file a motion, what's known as a motion pro hoc vice, in order to practice in that jurisdiction where he's not licensed. So the way that the court system is set up, there are all of these different jurisdictions. So each state has its own jurisdiction in the District of DC. So if I am licensed in, say, California, I took the California bar, I passed the bar, I met all the requirements, the California Supreme Court swore me in as an attorney in California. I'm licensed to practice in California, but I'm not licensed to practice in Arizona. In order to do that, I would either have to pass their bar or fulfill their particular requirements in Arizona to practice before their courts. One way of getting around that is to file a motion pro hoc vice in order to practice in the court where you're not licensed but seeking to practice. So that's what that is. So based on this entry, we can see that the defendant BAM Trading has been roped in, and they are represented by counsel as of November 3rd, 2021. Continuing on November 16th, there was a corporate disclosure statement that was filed. On December 10th, there's an entry that service was executed on one of the defendants. On December 14th, we can see there was an order denying the plaintiff's motion for alternative service. So what this tells me is that the plaintiff attempted service on one of the defendants and was unable to do so through traditional means. So in those cases, you can seek to have the court issue an order permitting alternative service, which is a method of service by alternative means, whether it be through public declaration, private process server. It depends on the scope of the court's order, how you can serve them. Continuing on December 15th, we can see that there was a dismissal for lack of jurisdiction. So based on that, it tells me that part of the suit was dismissed because the court found that it lacked jurisdiction over some of the causes of action or on some of the defendants. So there was a dismissal. I don't know the exact scope of it because I don't actually have access to that particular document. Right here, we could see on December 16th, there was an entry regarding the addition and termination of parties. So there are some shuffling around of the parties in this particular suit. And then the most recent entry on December 20th of 2021 was a reconsideration. So I'm assuming based on that, even though I don't have the document, so I can't decipher exactly what happened, based on the totality of everything that I have in front of me, either someone was dismissed or the plaintiff was issued an order that he didn't necessarily like, so they are trying to have the court reconsider that. So pretty much based on all this, we're still kind of in limbo. The plaintiff is dealing with all the headaches of properly serving all of the defendants and actually pushing this through the court system. This is going to be a long, arduous, dragged out process. We're going to keep tabs on this and keep you updated as this thing develops. Please check back with us to get any sort of update, and we'll notify you as they come in. All in all, as to where this goes from here, who's to say? I think that the plaintiffs, they made some pretty good points in their suit. I don't know necessarily if all of them will prevail in court. What often happens in these sorts of situations is that the defendants, especially when they have super deep pockets like this, end up settling out of court, and they just pretty much pay the plaintiff to go away. So the plaintiff here, let's say that hypothetically Binance offers to settle with this plaintiff, they can offer him a few $1 million and be like, hey, dismiss this case, it's done, go away. We're not going to disclose the terms of this settlement, but we don't want to deal with this anymore. We're just going to pay you to go away and get rid of this headache for us. So with all that said, I hope you guys like this content. If you liked it, please like and subscribe. Drop us a comment down below and let us know what you think. Also, please follow us on Twitter. We are at CryptoBitLaw. Thanks for watching, and we'll see you on the next video.